manager at
Right. Okay.
store,
Okay.
and then we went through I think
Protected
it was an assignment.
disclosures.
Yes, that as well. Yeah, I think that was and then we went through our assignment.
So, okay. Fine. What we're gonna touch on. All right. Okay. Okay. What we can touch on this evening is we're going to do another little exercise. Let me share my screen with you here. You all see that?
Not yet.
Okay. Hang on. Can you see it now?
Yeah, I can see.
Okay. It's the question. Aisha, can you see
Yes.
that? Okay, good. All right. So now let's get into it. Question is, Jack is employed as a male nurse. Now this was, yeah, we didn't do this one yet, yeah. Okay, so Jack is employed as a male nurse at the local hospital where he likes to frequent a nearby bar each night after his shift. However, Jack has been arriving at work severely hungover or still intoxicated from the previous night. After numerous complaints from patients and warnings from his employer, Jack is fired. The hospital's code of conduct granted each employee the right to appear before a disciplinary board before they are dismissed. Each employee then has the chance to plead their case before the board. Okay, simple enough facts. Do you think Jack's employer had a fair reason to dismiss him?
I'd say yes, they did.
Had a fair reason, huh?
Yes.
Because one needs a fair reason to dismiss somebody, of course, as we know.
Yes.
You know, and another word for fair, a fair reason is what we call substantive fairness.
Sub?
Okay. I said another name for a fair reason to dismiss somebody is called substantive fairness.
Oh, okay.
Okay. Because now under the LRA, one can only be dismissed if the dismissal is substantively fair and procedurally fair. What does substantive mean? Substantive means that there must be a good reason.
Okay.
Yeah, it's your constitutional, well, not your, it eventually is your constitutional, but it's a right that you have under the LRA not to be unfairly dismissed. There must be a reason. Now, what does the LRA consider to be a fair reason? What does it consider to be substantively fair? It has not given each and every ground, but it has broken it down into 3 areas, the 3 wide grounds. What do you call that?
Okay, that one I don't remember.
Yeah. Aisha? You can dismiss somebody for substantive fairness, right? But now what is substantive? What is considered fair, fair ground? There's 3 grounds basically.
Is it the The misconduct.
Alright, that's the first recognized ground. Conduct, misconduct, yes. Alright, so you can dismiss somebody for misconduct.
Okay, now. Incapacity and operational reasons.
That's it. Capacity and operational. Welcome back, Lizzie.
Hi, I was struggling with my network, but it's good to be back.
Yeah, no, me too. I was struggling. So these are the three grounds of what they consider to be substantive fairness: misconduct, incapacity, and operational requirements. And each of these grounds now have their own set of sub-requirements, you know, because misconduct, must be understood. It must be known what is considered to be a rule in the workplace that the employees will know will not be accepted, will not be breaking of the rule, will not be allowed. Right. So in a workplace, the coming late, for example, is that misconduct?
Yes.
Yes.
Misconduct of a different type of degree, but it's still misconduct. And theft and dishonesty, that is also misconduct. Okay, but there are different kinds of offenses and they are treated differently. Right. So misconduct cannot just be any, it must be a rule that is well known. It must be a rule that is applied consistently. It is a rule that must also be reasonable. Right. And the employee had to know about it, and then he broke the rule. Okay. And it has to be reasonable, so we need to judge that. Sometimes what is considered to be a rule, a reasonable rule, is a question of it has to be objectively viewed. Okay. For example, if one of the employees learns that one of his workers are pregnant, he may find that to be something very wrong morally to him, to the employer, for example. And I want to dismiss the person for getting pregnant, for example. But now we know, of course, that that is only his own sense of what's right and wrong there. It is not objectively wrong. Okay? And it must be reasonable as according to the rule of reasonableness in our civil law. So we look at all of those things. Okay. Obviously, there's certain core things from the employee and the employer relationship, related to your duties, each other's duties, that will obviously, we can start to see the rules of misconduct developing. Okay. Your working hours, so you must do it. Leaving early from work. Coming late is one thing, but leaving early, it's also another kind of, dishonesty. So there's many rules, and the rules must also be reasonable. Okay. Then incapacity, we're just dealing with these heads very broadly. Incapacity, what is that?
Isn't that when you, like, maybe you're not performing the way that you're supposed to, the role, or what the role requires you to perform at, and no matter what they do, they can't get you back to actually performing at the required standard?
Yes, that is one form of incapacity, yes. When we look at your competence and ability, right, to be able to perform the duties and responsibilities that is required in terms of the contract of employment. And the other incapacity is where it's due to your health.
Yeah.
Right. So it could be either permanent or it could be temporary health issue. Okay. You broke your legs and it's in a cast. Now you can't carry the heavy boxes. You have to wait till you heal first, as an example. Right. You can't dismiss somebody just like that. And both of these incapacity hearings are a bit complicated because for the competency incapacity, the employer cannot just automatically dismiss you. The employer must show that, look, it has gone through a lot of things to be able to accommodate you and to consider before imposing the sanction of dismissal. Okay? So if a person can't do a certain job, then you must try and do what you can before you eventually decide to dismiss that person. And it is reasonably, not everything, okay? These will differ from facts to facts. So if you get the secretary and, you get the secretary and you told the secretary, I need you to type 50 words a minute, the secretary can only come up to 40. Okay, so that's not so bad. So maybe you send her for training and you get her to do all kinds of things to try and improve. You do something, but yet, despite all your efforts, she's not living up to it, right? So the employer cannot dismiss you immediately for this. The employer must explore all other ways, not all, but all reasonable ways to see if they can accommodate you before they dismiss you. Okay, the same with sicknesses, whether it's temporary or permanent sicknesses.
Yeah, that one is very tricky.
Say again?
No, I just wanted to add that the incapacity for sickness, that is a headache, especially if it's an employee when you're dealing with mental illness. That's, yeah, because you can never get the proper paperwork to literally take steps against the employee. Yeah, that's just something that I come across, yes. Mm.
Yeah, no, it is quite a thing, eh? And it depends also how the employee, if it is a health issue, then there's various ways to approach it, and therefore employers must have policies in the workplace. They must create a policy in which they set out what will happen and how they will deal with an incapacity matter. Okay, if it's temporary temporary incapacity, in other words, like temporary illness, like an injury on work, then you must do what you can to accommodate the employee. Right? Like, sometimes they even pay you out, or they allow you extended leave, and they help with hospital bills sometimes. Okay, but if it's permanent, they must also have a policy on that. And some employers, especially the state as an employer, they have insurance in place. Some people want to get medically boarded. They want to be medically boarded, meaning that they are paid a sum of money, and the employer sometimes invests in policies, insurance policies, to assist with this kind of thing.
But okay, just to add another comment, sorry, I just find it interesting. Like with the specific example that I came across, like you might have all the policies, but then sometimes you need like confirmation from the doctors, and the doctors are telling you the person is okay, but you can see the person is not performing. So that's where the whole, because now you can't really take any further steps because they're being told no within 6 months, but there's no guarantees. But anyway, that was just a case that I came across in work where I used to work.
Yeah. No, at the end of the day, it will be up to the employer to show. Remember, how it works with dismissals is that once you go to the, to the CCMA, if you have a dismissal, now remember this, a dismissal means termination. It means the end of the employment contract. Okay. Now I want to give you a quick example. I don't know if I gave you this example before. That if you, for example, have a contract of employment that you've signed, and the contract says there, under the heading termination and giving notice, says there that either party to this contract may terminate this contract by giving the other party 30 days notice. So now your employer comes to you one day and says, thank you, Aisha, whoever you are. You've been working for us, but here's your notice at the end of the month. That's 30 days time. It will be your last day. Here's the notice to inform you about that. We'll be paying you salary, of course, and any back pay and leave pay, anything that we owe you. Okay. What is there anything the matter with that? Is there any would that be a lawful termination?
I think it would draw back to us just making sure we read these terms and conditions, because it sounds a bit extreme that they can just come and say, okay, 30 days notice just because you signed for it, and they terminate your employment. Surely there should be proper grounds for it. Like, isn't the employer supposed to explain reasons behind the decision to terminate your employment, even though they do give you that notice and whatnot? But don't they need to give proper reasons to explain why they're terminating your contract?
Yes. In fact, that is what we said now, isn't it? That you cannot be dismissed for nothing. It must be a dismissal must be substantively and procedurally fair.
Yeah.
Right. So what is the reason? If they're giving you the notice, surely there must be the reason. And the reason needs to fall under those categories over there.
Yeah.
Of this misconduct, capacity, or operational requirements. So this is a common mistake people make. And look how I can catch somebody off guard quickly because, well, I did sign for it, and it does say there that we can terminate this contract, and they are terminating it. So shame, it's me now. I've lost my job. No, the employer can't do that. That term won't be enforceable, or if they are trying to enforce it, you will take that to the CCMA, right? Because dismissals are referred to the CCMA. And how does it work? How does it work now? When you get to the CCMA, there's just two things you need to prove at first as the employee. What must you prove? Yes.
I think what you need to prove, won't it depend on what the reason for the dismissal is?
Well, you were dismissed now, right? You were dismissed. You were given this notice. They terminated the contract. And what was the reason for this? But what do you need to prove to get your matter heard with the CCMA?
That you are an employee and that you were dismissed.
Number one, you must prove that you're an employee. All right. And remember, from the very beginning, we were making it quite a point to establish the meaning and the application of the word employee, right, as compared to an independent contractor, which doesn't fall in the definition of an employee. So number one, you must prove you're an employee. Good. And number two,
you must prove that you were dismissed.
Good. So that is the two things you need to prove as an employee. Now, once you've proven that, and that's not difficult to prove in many cases, right? Even a verbal contract. Let's just go there quickly. Does the fact that you don't have a written contract of employment mean now that you don't have a valid employment contract in place?
Just a side question quickly. So if in the absence of both a written contract or a verbal, well, you don't, let's say, for example, I don't remember when we actually had the conversation where we agreed that I'll start working for X person, and then this happens, I get dismissed, and I don't have the necessary, what would count as other proof? Would me receiving a monthly salary from this person count as proof of me being deemed to be an employee, or would it basically mean I don't have grounds to go challenge it at the CCMA?
So what is the question exactly then?
The question is, do I have to have a written contract or like a verbal a verbal agreement. In the absence of that, would that mean I don't have a case at the CCMA?
That was my question to you. That the fact that you don't have a written contract doesn't mean you have an employment agreement, a valid agreement, and therefore can't refer it.
You can refer, because verbal contract also comes into place. But I think, like, if you were employed, wouldn't you have like pay slips and stuff like that as well? Because there's always something which you can use. And when you were terminated, was it like a verbal termination, or did you get some sort of like document to say you're being terminated as well?
Yeah. So the main question here is, the fact that you don't have a written contract, does it mean you don't have an employment contract? And the answer to that is no. What a contract in writing, makes easy. It makes the proof of the agreement easy. Right? That is what a written document basically benefits you. By proving that there was a contract, here is the terms of the contract and the conditions. But you have a verbal contract, it doesn't mean necessarily that there is no contract. Okay? We then have to look if it's disputed. The party who's proving the contract must now prove the terms. Okay? And that's where it becomes a bit difficult. So, like you rightly said, if that person denies that he employed you, but you got proof showing that they gave pay slips or they paid money into your bank account, or you've got witnesses saying, no, this person has been working at this place for long, then you can prove it. But it makes it, you have to lead all this and get all this evidence just to prove this point. Okay, but it's still a valid contract nonetheless. Okay, and
sorry, just one last question.
No, not a problem at all. Not a problem.
On a verbal contract, how would that work? Because I mean, it's just a conversation that took place. Only I know, and the next person knows that this is the conversation that we had. How does that hold water when we go to the CCMA? Is it going to be a matter of I said, he said, or what would happen?
Well, it will come down to a question of evidence.
Yeah.
Right. Now, remember, there were two things that you as the employee were required to prove when you came there.
Oh, yes.
One, that you were an employee. And you would have, like I said, you would have to prove it. So there's different kinds of evidence that you can have. It can be, it could be, pay slips that were issued. There could be bank statements indicating payments from the employer. So there is evidence that one can, substantiate, but just makes it more difficult to prove. That's all. And you need to prove this on a balance of probability. So you mustn't think that, I don't have a written contract that I don't therefore have. I'm not an employee. No, it's a very good thing to have, but the fact that it is not, you don't have one, doesn't mean that there's no valid contract. Right? Number one. Number two, even if you have a valid. Say again? What were you saying?
No, I was just saying I understand the explanation.
So,
yeah.
Okay. So, but now the fact that you have a written contract, okay? Sometimes you have a written contract. I gave you that example now. That with that notice period and termination clause, it says there that either party may terminate the contract on 30 days notice. So there's a written contract, there's even a term here. The contract is signed by both parties. But now we have a term. Aisha, what is wrong with that term? Okay, maybe Aisha is not there.
Yes,
what is wrong with that? Oh, okay.
Yeah.
So what's wrong with a term like that? That says either party can give 30 days notice.
Oh, I'm not with you.
No problem. Okay.
I'm
So
sorry.
my point, we're building on you. We're building on
Mhm.
the idea that number one, you don't actually need a written contract
Yes.
to prove that you're an employee. Okay, it's good to have one. It's good always to have a written contract for any transaction. But it makes it easier to prove the terms. And therefore, but the fact that you don't have one doesn't necessarily mean there is no agreement. Right? Now we come to the point that what happens if you actually do have a written contract, but some of the terms, like that term I gave you that example now, what if you have a contract Hello? Aisha, Liz, Sakani, can you hear me?
Yes, we
Yes.
can see you now.
Okay, thank
Okay.
goodness. Okay. Okay, it's going on, as you know. I don't know what it is, but it does happen, man. Sorry about that. Yeah, go in and come out and all this stuff. So, okay. We were talking about, how you as the employee, what you require to approve when you refer a matter to the CCMA. So for basically, this would apply for all those other referrals to the CCMA, not only unfair dismissals, but unfair labor practices, discrimination matters, things like that. You also have to prove you're an employee. Okay, and you'll have to prove certain discrimination. Okay, if it was an unfair labor practice. Now, the fact that you don't have a written contract doesn't mean that the contract is no contract. It just makes it difficult for you to prove the terms. But the point I was trying to make was that what happens if you do have a written contract? The complexity comes about when you have a written contract, but then there's problems with that contract. And yet you've signed it. You gave the example of contract saying that either party may give notice to the other. Now that you must interpret that. That can only apply when the employer has substantive grounds to dismiss you. It just doesn't mean automatic notice. Okay, so you will have to interpret the contract. So certain terms of contracts must be carefully scrutinized to see whether they comply with labor laws. Okay, what about the law that says in the term in the contract it says, well, your working hours will be from 8 till 8 in the evening and Monday to Friday, and Sundays you're required, every second Sunday you're required to work on a Sunday. There's no mention of overtime, and it even says you will not be paid overtime for that. What does this mean? Yet you signed it, okay, I accept that, yes, it's fine. Accept that. What does that mean? Now, what does this mean for you as the employee? And what does it also mean for the employer?
I think my 2 cents. I think as an employer, obviously, wouldn't that make the contract or those terms null and void in a sense? Because at the end of the day, you still need to make sure your rules, procedures, whatever you put in place, is in line with the labor relations or BCA, because it stipulates like when it comes overtime and all that, and you can't put in like a condition which is in direct conflict with that.
Very good. That is the main point of this entire exercise. Okay. That you, when you are presented with a contract of employment, you must realize how the labor laws affect it. Okay. So, for example, the Basic Conditions of Employment Act says that these are the basic minimums. That's what it's called. The basic conditions. So, in other words, you cannot, as an employer, contract with your employees below these basic minimums. You can contract above them. In other words, for example, that you are given a certain amount of leave, but the employer can't give you less leave. You can't agree to less, but you can agree to more above the basic requirements, the basic conditions. This is what you must look for in all contracts. And many people make the mistake an interpretation of these contracts. Okay, we've signed it, it says that, but not actually if it goes against the existing labor laws. So number one, you must prove, if you're referring a matter to the CCMA, that you are an employee, and two, that you were dismissed. Okay. What then happens? Let's say you're successful in proving that at the CCMA. Right? What must happen now?
The employer must
Yes.
prove the dismissal was not unfair. There was fair reason to dismiss the employee, substantive fairness, so that reason misconduct. If it was misconduct, give the reasons why.
Right. So a big thing happens now, guys. You shown that you are an employee and you were dismissed. Now the law says, okay, the onus now moves now from you, the employee, and moves to the employer now to prove that dismissal was fair. Employer must show, why we fired this person or why we dismissed that person was for the following. And you must now prove that the dismissal was substantively fair and procedurally. Okay. And then you as an employee have an opportunity also to answer the employer's, evidence, because the employer must prove now we dismiss this person, incapacity. Now, incapacity is such a complicated one. So is operational requirements. By far, the most common hearings for dismissal are because of misconduct. People are breaching the contract in various ways, like breaking the rule. Okay, but for incapacity, which is quite complicated, okay, which involves complex interpretations of policies and also the labor laws,
Your network is breaking up. We can't hear.
Hang on, guys. Yeah, I'm getting this message here to my network quality. Okay.
Much better now. Much better.
Better now? Okay.
Yes.
So what considers substantive fairness means that you must have a reason, as I've indicated to you, the three main reasons, and then you must follow over and above that, there must also be a fair procedure that was followed. Now, misconduct, employer must have a policy about misconduct. Employer must have a policy on incapacity. Employer must have a policy on operational risk. So the employer must show that it has done all that it said it would in terms of its own policy before it effected the dismissal of the employee. Okay? So you must do everything from an incapacity point of view. You would have to show what you all did, number one. And number two, you must follow a fair procedure. Okay? I'll give you an example. I catch my employee stealing money from the till. Okay? And I catch him red-handed. It's on camera also and everything. So I smack him. Okay, maybe I don't smack him. I shout at him and I tell him to get out and never come back. And that is it. Well, what can that employee do? Can that employee do anything against me as the employer that told him to leave? Yes.
I think either way, okay, the employer still needs to follow the same steps. There still needs to be a hearing.
Yes.
You understand? Just to
So
make sure
that question, the employer, yeah. So there, the same thing can be asked. Did the employer have a good reason to fire the person? Yes. The employer did. Theft and is a very bad deed, and it's misconduct. And secondly, you should have a procedure. So you will go to the CCMA, and the CCMA will find that yes, the employer did have a good reason, but the employer never held a disciplinary hearing, and therefore he was unfairly dismissed. Okay? Because of procedural unfairness. So when you fail to follow a procedure, it makes the whole dismissal unfair as well. Is that clear?
Yes.
Now, okay. Okay, so you must, as the employer, you must get both right. You can't only get the one right. You have to get both right to be successful in your dismissal of your employee. Yeah. So it's misconduct, it's incapacity. There's a third ground, operational requirement. Does anybody have any idea what that is?
Sorry, I talk a lot.
No,
Operational.
no, it's good you talk a lot. I don't want to be. I'm the one that talks a lot. Yeah, you go ahead.
When I think of operational requirements, I think that applies, for example, where a company is restructuring for, okay, now I wanted to say for operational reasons, they are restructuring or they are retrenching employees. That as well, then there's steps which they need to follow, because you can't just retrench. You need to justify and show that you've tried to what do you call it? Accommodate employees. But it's a whole process, steps that you need to follow before you even get to a point where you dismiss the employees or you put them in, you demote them to lower paying positions and all the stuff. So it can mean a lot of things.
Yeah. So in essence, that is it. When there is economic, financial, or structural, changes in the company, which make it sort of impossible for the employer to continue employing you. Okay. Because an employer is basically just a business anyway. So if the business is doing badly, the business can't sustain all the people and start to change. Okay, so for excuse me, because of technological, financial, economic, or structural, or similar needs, the organization is unable to continue employ people, then it may dismiss you based on this ground. It is the substantive part, but the procedural part is quite comprehensive. Okay? And the Labor Relations Act, Section 189, deals with scenarios with employees with more than 50 or less than 50 employees. Okay, the more employees you have, the more involved you need to be in consulting them with this decision. If you're a large company, you in the textile industry and you make clothing for Woolworths, you employ 5,000 people all over country, and you got like 2,000 people that work in the factory, many of your factories. Think about that, guys. It's a big thing. Now Woolworths turns around and says, sorry, man, we're canceling our contract with you. Now what you got? You got all these expenses, but you won't be able to pay. So that would be a good reason. But you have to follow the procedure. You'll have to consult the people. You have to inform them timeously. You would have to look at all options other than dismissal. Okay, so there's many other options you can consider. Well, okay, we can try and push on. Let's make it shorter times. Let's you put people on short time. Let's pay less to people. All these things. And eventually, if you can't help it, then you have to then fire people on the principle of LIFO, last in, first out. And yeah, that is unfortunately happening a lot now with the COVID pandemic having come about. So operational requirements. Now those are the three, substantive basis of substantive fairness. But now there's another kind of dismissal. Okay, Section 186 of the LRA tells you what a dismissal means, okay, and you guys can look at that. But we're talking about the unfair dismissal now, right? Because you're allowed to dismiss, but you cannot dismiss unfairly, as long as it's fair. So misconduct, incapacity, operational requirements. But is there another form of dismissal that you can think of? Have you ever heard of this concept by any chance? It's known as does anybody have any idea what this is about?
Constructive dismissal.
Ah.
Yes. Yes.
What is this about?
From my understanding, constructive dismissal, it's where an employer makes the I won't say living conditions, the working conditions so unbearable for the employee that she ends up resigning. So you're not resigning because you are leaving, you are resigning because the environment is so toxic that you can't, yeah, somewhere in those lines.
Yes, basically, under section 186(1)(e), it's when the employer makes further employment intolerable for the employee. Okay, you there?
Yes.
Oh, okay, good. So this is not any action on the well. That's just the thing, because remember, if you refer an unfair dismissal to the CCMA, we agree you must prove two things. What's those two things again? You must prove you're an employee, and you must prove that you were dismissed. But now, when you leave the employ of the employer, you are resigning. So they will say to you, sorry, if you were not dismissed, this is not an unfair dismissal in that way. But this is an exception where you now are saying, look, it's a constructive dismissal. Yes, I was not dismissed. I resigned, I left, but I only left because the employer made further employment intolerable for me. I couldn't bear it anymore. And what is intolerable? What is considered to be intolerable? It's an objective test. We need to look at objectivity to compare to the reasonable person standard. Because what may be intolerable for you might not be intolerable for somebody else. So everybody can simply say, oh, I couldn't take it. Every Friday they had this practice where we had to buy cake for the boss, and that I just couldn't take it. And that was intolerable, and therefore I resigned. Would that be constructive as a constructive dismissal? Would you qualify for that? Is that intolerable for you? For you, perhaps. But not. Yes, Aisha?
No, you can continue.
Yeah. So you must be careful that you mustn't abuse this in the sense that some people think, oh, I will just resign and then take them to court again for a constructive dismissal. Can you think of examples that would be considered intolerable?
Sexual harassment.
Yes, definitely. What else? There's been court cases on this, and decisions. Yes?
Discrimination.
Discrimination. But now that is a you
Another
see,
act.
now remember, what is the law? That is a very interesting point you make. Because doesn't the law say to you that there's other ways while you're employed, right? Remember, this is dismissal now, you've left. But if you've got a problem, before you can be successful in a constructive dismissal matter, you're going to have to show that, look, I was working, I incurred a problem there, and I tried to resolve it. So there must be some effort from your part to try and show that you tried to resolve the problem. All right? You can't just say like, you without trying to attempt to solve the problem, to come to an agreement. So typically what would happen is that your complaints, or your grievances that you have were ignored. So if you were being discriminated against in the workplace, what else could you have done besides just resigning?
You could have lodged a grievance.
Yes, and then if the grievance if they said that your grievance was ignored, what could you then do besides resigning?
You can go to the CCMA.
For what? On what grounds, I mean? Besides now resigning and coming to the CCMA for unconstructive dismissal. So it depends on the nature of your work, right? In the nature of your grievance. If it is an unlawful discrimination matter, you can take it to the. If it's an unfair labor practice, right? You must take it to the CCMA. And therefore, you're not dismissed now. You didn't resign. So therefore, you must be careful before resigning. You should try and resolve it through the CCMA as an unfair labor practice if it qualifies to be one. And you can also take it there as an unlawful discrimination matter if it qualifies to be one. Each of them have their own different requirements, if you can remember. Right? Unfair labor practice is any act or omission on the part of the employer with regard to the employee which involves unfair promotion or demotion or probation rights or benefits or training. It also involves unfair suspension and any conduct that is short of dismissal. So, before you resign, you must show that, look, I've tried everything, and perhaps this is an argument that must actually be properly, made in front of a CCMA arbitrator. Why did couldn't the person have referred the matter to the CCMA, not as a constructive dismissal, but rather as a unfair labor practice if it was, or a unlawful discrimination matter if it is another. But the courts have taken sort of a view that certain conducts are so bad that, like sexual harassment is considered to be traumatic, and women are not expected to tolerate things like that. And if they leave, they can easily take the employer to, to the CCMA. And over and above that, if the employer did nothing about it, or doesn't even have a policy in place for it, the employee can also hold the employer civilly liable for damages over and above this. Grobler case versus the Naspers case. Okay. Where this woman sued the company where they just didn't take steps they ignored her pleas when she was being sexually harassed by her boss. And she got obviously paid for the CCMA as well as over and above it civil damages. Okay. So these are your dismissals now. So we go back to this question. Having now said all of this, let's go back to the question. So now about Jack. Jack is now a male nurse. So do you think the employer had a fair reason to dismiss him? Yes, on the face of it, it appears to be so. Right. And what was the fair reason, guys? What would be the fair reason to dismiss Jack?
Misconduct.
Misconduct, yeah. Okay, so you believe there should be a misconduct charge and a misconduct hearing. Jack. Right?
Yes.
But now, guys, this is a bit of this is not because the question doesn't give us much further information. It's going to ask you more questions. Do you think the employer should have tried other ways to assist Jack instead of just giving him warnings?
Yes.
Yes. Yes.
Because have like referred him to alcohol, something to, because it can be of his work.
For counseling.
Yeah.
There you're on the right track there. That if it's because of the work, look, the man works as a nurse in the hospital, right? And he goes to the boss. It's a stressful situation. It's night hours. He can say, look, actually, I'm an alcoholic. In the courts or the CCM has said, in such a case, when an employee says that I'm an alcoholic, then you can't actually, you need to treat them a bit more sympathetic. You can't just dismiss them. You would have to look at having an incapacity hearing rather. So that is why the second question is, do you think they should have tried other ways? Of course they should have. They just gave him warnings, but they should have found out from him. Why are you drinking? What's going on? Right? They get the complaints from people and from patients even that he's doing it, and they don't investigate. They must investigate, because what is a warning, by the way? So if an employer gives you a warning, what is that? It's an example of what?
Trying to get you to correct your ways and align with
So
whatever.
what is it? Yes, it has. It's supposed to have that effect, but what is it in essence?
It's a warning.
Yeah, but what is a warning? A warning is a type of punishment, isn't it?
Yes.
Can I warn you for something that you didn't do?
No.
In other words, you are warning me because you believe something.
Mm.
Right? You believe that you are doing something wrong, and you are telling me that, okay, I'm warning you. I see you are doing this. I've already made a sort of decision about you. Right? I've already kind of, in my mind, said this person has done this and that wrong, and therefore I'm warning you. You just don't warn people for nothing. It's because you firmly believe something that the person has done wrong already. All right, so already there's some procedural problem here. So the question is quite right to ask, should they have investigated, or should they have gone to look at other ways to help him? And the answer is yes, they should have looked at other ways, because then they may have discovered certain things about Jack's condition. Okay, so you, in fact, as an employer, you're required to help your workers if they got problems like this, health problems. Okay, and especially if he's going to say, look, the night shifts are too much for me, I can't take it, it's stressing me out, it's dangerous to go at night, and the work is hard, and if you change me on the day shift, perhaps, so things like this you must look at. Because if that is the case, you can't hold a misconduct hearing, you have to hold an incapacity. So the next question, do you think the employer has a duty to establish why Jack frequented the bar? I think we've answered that question now, isn't it?
Yeah, we did.
Yes, that they want to find out, they should have done that, because then they would have known what kind of hearing to hold, whether it is he's going there for fun and pleasure, not because he's got a health issue or stress issue, it's because he just wants to. And then they would be truly justified in having a misconduct hearing, right?
Mm-hmm.
And then lastly, do you think it would be fair of Jack's employer to deny him an opportunity to present his case before disciplinary hearing?
You think it would be fair? No, it's not fair.
It would be fair to deny him.
No, it's not fair.
No, it's not. Yeah, of course not.
You need to
But
follow
okay, but hold on. He was given warnings. Told not to do this. So why must they call another hearing? Or another call into a hearing when he knows already he's been told not to do it.
Yeah, but he needs to be given an opportunity to to defend himself and to present evidence as well.
Excellent, because that is the thing. If they now didn't hold the hearing and they dismissed him like they did now, what is wrong now on the employer side? What has happened now? Right?
I didn't catch the question.
So
So
I asked now that, look, they have dismissed this guy now and they didn't hold the hearing. So and you said, no, it won't be fair, it's unfair. So what is the effect of this decision not to give him the hearing now?
it's procedurally unfair, and he can actually
And therefore
refer them to
an
the
unfair
CCMA.
dismissal.
Yes.
Yes.
Thank you.
It makes the whole thing. You see, many people don't understand that simple thing, man. You know, or they think they do. You know, it's actually people when they hear things like this, they believe, okay, this man was wrong, he's drunk at work. And it's a simple, open and shut matter. It's simple. The man was wrong and he must be fired. He got warning. So as in law, the requirements are different, right? You must give a person that opportunity. More so in this case. Why? What happened? What makes it even more of a requirement on these facts? That they should have had a hearing. Hey guys? What makes it particularly unfair in this case on these facts that they should have had a hearing? Nobody? Isn't it the fact that they've got a disciplinary code at the work that says that you must have a and where they can plead their case?
Sorry, your line was breaking there. I didn't hear the last few words you said.